Hello, it's Phillip Taylor speaking from Richmond, Green Chambers in London. Today I'm looking at a book which has come to us from Intersentia. They specialise in publishing books covering European Union law, very much with emphasis on Europe in terms of law, but it has a very substantial bearing, of course, on what we do in our common law jurisdiction here in the United Kingdom, certainly in England and Wales. The reason I'm actually reviewing this book is because the law of tort itself is effectively something which, as a civil wrong, the word tort of course is French for civil wrong in olden times, so therefore it's emerged as part of the common law. This book is called Prescription in Tort Law, and it's an edited book with a collection of contributions. It's been edited by Israel Gilead and Bjarte Askeland. I hope I pronounced those names correctly. I'm sorry if I got it a bit wrong. But this is, as I say, from Intersentia. The book itself, it's over here. It's called Prescription in Tort Law, and it's actually part of the European Group on Tort Law publications. Now, what I've given for this review title is it's a welcome statement on a view of tort from effectively a European perspective. And that's really what you're getting with any of the publications from Intersentia. Let's have a look at the book first of all. It's a paperback, there it is. It's actually a heavy book, and there's the spine, you can probably just see that. Then you probably can't make out very much of the wording. As I say, this is a heavy book. It's been written in conjunction with a number of people. The back of the book has information about the editors, so it's in reverse to what we're normally looking at, and of course you've got quite a lot of information at the back of the book. It runs to nearly 800 pages. This is a questionnaire in the form of one of the appendices at the back. It's the Appendix Questionnaire, and it's got a series of questions arising from the various chapters. And then of course you've got the individual chapters at the end. Just getting to those. There is no index as such, which I think is a little bit of a drawback, putting it bluntly. But as I say, the basic approach, you can see what we have here. You've got a form of paragraph numbering at the side. You've got footnoting, which you can probably see at the bottom. So there's a lot of information. And then what you have got, of course, as I say, is back the appendix, which is in the form. It says it's in the course of the analytical and comparative discussions that have taken place. The questionnaire sets out some additional points that you might find of some use. This is the front page, and you can see the subtitle is Analytical and Comparative Perspectives, something that they actually are very good at producing. There is a dedication. We only review books that we think are important, so I don't bother with those books which I don't think that much of. The reason is that people have put a lot of work into the books, and I don't want to criticise them if I just don't happen to like the book. You can see the content section is very detailed, so that will make up for the fact that there is no index. And again, you can see the various different chapters. It's by country, and it names the people who are the contributors. There are a large number of people who are listed, and you can see the names there and on the second page. And then after that we get into the various parts, part one being theoretical and comparative analysis. Then you've got another much more detailed index just for that part. And just running through that, again you can see the various chapter headings if I just show them to you. And then after that you've got the beginning of the book itself, and you can see a subheading, and then you've got the paragraph numbering all the way through with extensive footnoting. I'm just running in the middle of the book the same approach. So there is the book, as I say, 800 odd pages in total, and it's a very learned tome, and you can see EGTL, which is European Group on Tort Law. Now what do we say? It's a new work from Intersentia, and it's called Prescription in Tort Law. And it's been edited by, as I say, Israel Gilead and Bjarte Askeland, and it's the result of a 3-year research project led by this European group on tort law, and it brings together leading academics in the field of tortious liability. And I feel, as a practitioner in the English courts, that it would be of some interest to me just to get an idea of the thinking in terms of comparative law, and that's really why it's worth a good look at. We concur, of course, with the view that's put forward that it's an invaluable resource for private legal practitioners, for academics and researchers, and of course for students. And the prescription, the word prescription, which is being used here, has been actually defined, quote, as a major legal defence that bars civil actions on the claims after the expiry of a certain period of time. In other words, what is described as the expedient policy of finality of proceedings. Now, we have finality of proceedings in many areas that we operate in because, as I found with my practice, there are quite a large number of clients who just will not accept the decisions of one or even two courts, and they will continue coming back. And eventually you have to say, no, enough is enough. You've made your position known. If it's a complaint, you can complain and complain and complain, but you have to draw the line somewhere. And it's effectively a limitation, although the word prescription is used here. Now, of course, despite its far-reaching practical effects on the way in which we litigate and on society at large and what society thinks should happen with these sorts of cases, and the fact that it is the subject matter of what is called pervasive legal reforms in many parts of the world, the law of prescription, as it's called here, which is a limitation of actions as we know it under common law, is rarely analysed, discussed and compared in most legal literature. So I'm glad that we've got this book to assist the process. And of course, what the editors have done with the contributors to meet the challenge is actually looked for in-depth views on the law of 15 selected jurisdictions, which cover, of course, continents: Europe, South Africa, and the United States of America jurisdictions in particular. And there's an extensive analysis and basically a review of comparative perspectives and the elements of this concept of prescription, which is the accrual, if you like, of a cause of action, the way the prescription periods run, rules of suspension, renewal, extension, and so forth. Because, like all jurisdictions, you eventually end up, you give the litigant a certain amount of latitude, but eventually you have to call a halt to the proceedings. And of course, it's important when we're looking at interrelations between the parties and the policy considerations which many countries have, including what is described as an economic analysis, that again you eventually have to call a halt to what's happening. Now, of course, in a jurisdiction like the United Kingdom jurisdiction, one of the biggest concerns, which is why we had Brexit, was because the British view was that the final court of appeal, if you like, for hearings was, of course, the House of Lords in its appellate jurisdiction, sitting as an appellate committee, and now, of course, the Supreme Court, the United Kingdom Supreme Court. Of course, the problem was that there were further appeals from that court to Europe, which, of course, was resented by many people, hence the view that the public in Britain voted to leave Europe and to try to reassert their own sovereignty. At least that's one argument that's put forward. I can see the concepts, although I'm not necessarily a supporter of Brexit, and I never have been. Now, the topics in this book also cover and include notions of what we call the words action, claim, cause of action, and they look at subjective and objective prescription as a whole, that's a limitation, the statutory interpretation, and of course the judicial discretion that operates, because judges are human beings. They get fed up with this after a while. I've been in court where you see the judge getting to a position where he thinks, I've had enough of this, I'm not going to listen to any more of this nonsense, and they'll stop the proceedings. Obviously you do, in the lower courts where I practice, have the right to go higher up, but remember it costs. That's the big thing, it costs a lot of money. And of course the book concludes with how the present law can be improved and where suitable harmonisation might take place, because whilst I'm pro-European and I'm, as I've indicated, a Remainer, although that's all gone now because Britain has left the European Union, the point that I would say is that we still want to have some sort of harmonisation in terms of internationally recognised laws. Now, that's within the sane countries within the world. There are, of course, a large number of countries that do not operate on the same lines, North Korea, for instance, and a number of other despotic regimes. But for sensible countries that are responsible, we are looking for that harmonisation which we need. And of course, while its main focus in this work is the prescription of tort claims, the analysis, comparison and the conclusions, I think, will be highly relevant to most civil actions across the board. Now, the date of publication of this paperback is cited at October 2020, and I'm recording this towards the end of the year. Let's just have one last look at the book. There it is. It's a heavy book, as I say. There's a lot of information on the back which you can't see. A lot of detail which I've tried to avoid. If I'm opening the book in the middle, you can see we're looking at Italy here. So there's the name of the country up there. You've got the nature of prescription and its effects in Italy, and you can see there's a statement, there's a lot of justification in the footnotes, you've got the paragraph numbering at the sides, but as I say, the big drawback I've found is that there is no index. And of course, just to remind you, the two editors, the information about them is contained in the back. And at the front, you've got a list of the substantial number of contributors. A very big thank you to Intersentia. I think this is a first-class book, and keep up the good work. Bye-bye for now.